not understand, okay, fine, what exactly it means to boycott judges, and will this continue against any number of judges going forward? What is your intention? What do you intend this to achieve?
Well, thank you very much. Let me first say that the judiciary occupies a constitutional position in our social, economic, political architecture. And we as a Kenyan people decided at the get-go, even before colonialism, the issue of justice in society was entrenched in every culture that I know of. If you notice, when the African societies were set up before colonization, I don't think you can find any place, at least in Africa, or let me just confine myself to the Kenyan context, because in West Africa there were scenarios that you could find a cell to hold quote-unquote criminals. So in African societies, there were norms, there were taboos, there were cultures that the society nurtured people from a very tender age to recognize, to respect, to uphold as the rules of existence. Come colonization, then we have the British system of governance, and the judicial arm was erected. Up to this day, it bears these foreign structures to it. And the expressions, even in the court today, of the parameters of adjudication and delivery of justice are still couched in foreign terms, Latin maxims. You have one maxim that says that that which is illegal from the beginning cannot vest in you subsequently any right if from the beginning it was illegal. The Latin maxim used in court to a stranger, you will hear ex turpi causa oritur non actio. That's a legal, it's a legal maxim. It's used today. So the Kenyan person is confronted without legal representation with that strange expression. But it is basically to say, if you stole something, your root of possession and title to that is fatal. You cannot pass any better title to somebody else. You cannot sell something that you stole. So we have the judiciary today erected as an institution to deliver justice, but it enjoys a monopoly. Now, there is the right to access justice, which is found in Article 48 of the Constitution. And once you find yourself in the justice system, there is a hierarchy of the courts, beginning with the tribunals that are established, like the Transport Appeals Tribunal, where if the NTSA does a decision that you're aggrieved by, then you can appeal under Section 38 to the Transport Appeals Tribunal, the Electricity Tribunal, the Tax Tribunal. So at that level, you then find the lowest instrumentality of the judiciary now to which you can secure justice. Then you go to the Chief Magistrate's Court, which then have a hierarchy, the High Court, then the Court of Appeal, and ultimately the Supreme Court. Now, all these are manned by personnel that are hired by the Judicial Service Commission. And there is a basic assumption that these personnel, the staff that man the institution at that basic level, should I say administrative level, all the way up to the highest level of the Chief Justice, that they have subscribed to the Code of Conduct. And that's by law. In the Judicial Service Code of Conduct, you find parameters of conduct that a judge and a judicial officer, that means someone who's a clerk or a court administrator in the justice system, must abide by. They have to subscribe, they have to sign that too. Now the question is now, on a practical daily basis, in their functional services or service rendering, do they live up to these particular expectations in the code? So you find corruption, for instance, but bias, nepotism, sexual harassment, and so on and so forth. All those are supposed to be then resolved, if you have a complaint, by the Judicial Service Commission. So the Judicial Service Commission is an instrumentality by means of which a resolution implicating the judiciary or the judicial officers should be resolved. Now you have a separate arm called the Ombudsman. The Ombudsman is supposed then to inquire such administrative or other complaints that you may have against public officers, including they who are in the judiciary. Now, what has happened is that complaints are leveled, and
before the judicial,
before the judicial, the JSC, and the JSC has a law society representative, a member from the bench, that is the judges, the magistrates, and so on and so forth. I'm not going to go into that because of time. But that JSC being vested now with the power to investigate the conduct that is complained of against a judicial officer is again presumed to be objective about the law, apolitical, meaning that it doesn't, side with this side or the other side of the political divide. And it's supposed to be very objective, fair, and all those tenets are there. But the question is, do they intend to abide by those principles and precepts?
The Judicial Service Commission.
Now, you find that if a judge, for instance, has had complaints against him or her, and they then are not prepared to go before the JSC and objectively have that dispute resolved, they rush to the High Court in the manner and the style that he can attest to the violence in Okalau, the bribery and all of that. A certain member of Parliament, of the National Assembly, was found by the Electoral Commission's committee to be guilty of electoral offences. And then he rushed to the High Court. And the Judicial Review Division then gave him an order to stop the finding taking effect. The fine he couldn't pay because of it's kept in a frozen state until now the case is heard and determined. Now everybody has a right to access justice, like I said, under Article 48. Everybody has a right to a fair trial under Article 25C, Subarticle C of the Constitution, as read with Article 50, Subarticle 1 of the Constitution. However, the High Court at that level intervenes. In other words, this judge with a complaint before the Judicial Service Commission
goes before another judge.
Now, we do not know, and I don't want to cast aspersions on any judicial officer. We do not know how this judge with a complaint is professionally related with a judge now, hearing his or her complaint, or saying that, the JSC isn't like to give me a fair hearing, the JSC is, whatever it is. So you find that state of the freezing of the Judicial Service Commission complaint is perpetuated over a long period of time. In the meanwhile, and because the whatever is suspended, the inquiry is suspended, this judge, he continues.
He continues.
Yes. But you must remember, the initial complaint before the JSC against this particular judge may have been corruption. So the act of freezing this inquiry does not, stop this judge from continuing to receive bribes. There's one particular judge, for instance, who has a complaint in the public domain that, he was so brazen that, the demand for the bribe was so brazen. And so that is a problem which is there. Now, I'm not saying that I support the idea that the advocate should then boycott cases because you're in a fiduciary position as a lawyer. A client has come to you,
You do not support the boycott that took place yesterday?
No. Hear me out. I do not wholly. Because I'm saying here there's a failure on the part of the JSC which has led to this scenario. And there is a collapse of the communication because the Chief Justice was saying in her statement that, look, we do have a forum And this forum of the senior counsel and other members of the bar, and plus now the magistrates and the judges, should resolve this like an in-house thing. However, the person who suffers most is that very consumer of justice. I must remind Kenyans, Article 46 of the Constitution does say that your consumer rights extend to services rendered by the government.
Okay.
And the judiciary is failing. And one of the areas that the judiciary is failing is because the Chief Justice, in cahoots with, I'm going to say this with respect to her.
Yes.
Because it's a pending court case.
And we'll be back to you, Wakili, in a short while, because we also want Wakili Nyamori to join the panel so that he can...
Is having this e-filing system, and it fails. And so you find that you, as a lawyer, you have the obligation to your client. You're unable then to file this case, not because of your fault, not because of your client's fault, but because of the judiciary's system of filing.
Okay.
And they have railroaded everybody else into it. Now that poor, the indigent person, who is unable then to access the e-system, the electronic, the digital filing system, you've cut him or her off.
Okay.
You've denied him justice.
So quite a number of lawyers allege judicial corruption and misconduct, chronic delays in case determination, registry inefficiencies, what you mentioned, e-filing disruptions and poor case management, discourteous treatment of advocates, weak mechanisms for handling complaints against judicial officers. But